right, guys, what is up? Welcome back to the Transparency, Idaho4, and the Shanna Gardner case. We're going to do a frank side-by-side comparison. I think it's important. I mean, I'm more or less doing this episode for myself. It's like, how can defense attorneys earn a Franks hearing? I mean, what do you have to do? What do you have to show to show this, to meet this burden, to be able to say, hey, we got to talk. There was no probable cause here. And so first I want to go to Shanna Gardner's motion that she filed. She is trying to suppress 3 items: Google, iCloud, and then her phone. Okay, so 3 things: Google, a Google search warrant, an iCloud search warrant, and her phone. Okay. And now in the Brian Colbert case, Google was one of the things, right? But there was like, well, they kind of say it right here. Look at this. It was 25. Hold on one second. Now I'm going to have to try to find my spot. Hold on one second. I was doing a million things this morning. They did not use the court, anything that Brett Payne had to say. Hang tight here. Okay, here. I'm going to share a different page first and then come back. Okay. So this is how Judge Hippler determined the order on defendant's motion for a Franks hearing. Okay. Let me just make it a little bigger. What is up, K. Schmidt? Woo woo in the house. Woo woo in the house. If you turn green, it was because of K. Schmidt. Thank K. Schmidt there. The state responds that the defendant has failed to make the requisite substantial preliminary showing under Franks that, number 1, law enforcement either made false statements or omitted material information knowingly and intentionally or with the reckless disregard for the truth, and or that the false statements or omissions were necessary to a finding of probable cause. Now, again, the state's response is that the defendant has failed to make this substantial preliminary showing. In Shanna Gardner's case, the motion was, I think, 12 pages. Mario Saldana's was 17. Okay. In the Idaho4 case, the defendant's motion for a Franks hearing was accompanied by a memorandum in support of a Franks hearing and a USB containing exhibits, 1,951 pages. Okay, filed November 18th, 2024. Original exhibits. The court subsequently issued an order requesting that defendant file an amended memorandum containing specific cites to the record and revise his original exhibits to include only those relevant to the motion. Then they refiled it, and it was still 1,010 pages. 1,010 pages. The revised exhibits, however, only included excerpts of the search warrant affidavits being challenged. To properly consider a Franks motion, the court must necessarily consider the search warrant affidavits in their entirety to determine whether probable cause is affected. Okay. So I just have a question right off the rip. I'm going to make this bigger. And my question is do we have to restate the record? Or is it that those search warrants are not part of the record yet? Just like, hear me out. We're going to go to like the very basic here because I want to know why Shanna Gardner, where are her exhibits of where are her exhibits attaching the search warrants with the affidavit? You understand my question? Now, so that's number one. It's like, which I would think would be like exhibit A. Like, well, first of all, there was 25 search warrants in this case. So you would have 25 exhibits, right? Or whatever search warrants you're saying are invalid. You'd be having those search warrants with the affidavit as exhibits, 1 through however many, right? Okay. So you're going to sit here and tell me that Ann Taylor doesn't fucking know that? Hang tight. Consequently, the evidence considered by the court for this motion is defendant's revised exhibits as supplemented by exhibits D2, D3A, and D3B from the original exhibits. References in this order to amended motions, what that is, means defendant's amended memorandum or amended memorandum. References in this order to exhibits are from the revised exhibits as supplemented. So what Ann Taylor went and did is the most important thing here would be to leave the search warrants as is, right? What the hell is this shit? To leave the search warrants as is, right? And because how are you getting to 1,090 some page, 9,000, basically 1,900 pages got reduced to, let's just say, easy math, 1,000. It was like 1,010. You reduced it almost 1,000 pages because it was like 1957 or something. Okay, you reduced it 1,000 pages. Why are you touching the search warrant? Okay, because I think this is ineffective assistance of counsel. Like, what the fuck what's going on here? Okay. But then I was like, let's do a side by side with Shanna Gardner case because it's going in, it's like it's happening now. So here's in Shanna Gardner's case, literally, I read you guys the motion the other night. Let me get this. That's Karen Reed. Okay. Here we go. Defendant's motion to suppress evidence obtained pursuant to unlawful search warrants and for a Franks hearing. Okay. So the 3 warrants challenged here. So just like how I said, there's 3 warrants that are being challenged here in Shanna Gardner, which is Miss Gardner's iPhone, her iCloud account, and her Google account. They are constitutionally defective on 2 independent grounds. Okay. So I wanted to compare the arguments that were being made. Okay. So I want everybody to see that right here. The court should not give the government an opportunity to present its evidence on the validity of the warrant without converting the hearing into a full evidentiary Franks hearing, including full cross-examination of government witnesses. So consequently, on those challenges, the court is only relying on defendant's exhibits and the parties' arguments. Do you understand that would mean that any testimony given by Officer Payne at that hearing and anybody else, like, what? Why the hell did he interview? Why the heck did he be called? Why was Payne called? Why were Gamut and what? Look at this. The court notes that in response to some of the Franks challenges, the state submitted and argued evidence that was not included in defendant's proffer. While this evidence can be considered at a Franks hearing, this stage only permits the court to consider whether defendant has made the substantial preliminary showing under Franks to warrant that hearing. Now, I would think that Officer Payne's testimony at the Franks hearing to say that law enforcement had never heard of and did not have the name Brian Kohlberger prior to December 19th. Okay. In and of itself, right there, tells you, okay, that nothing besides IgG was used. Okay. Now, either Officer Payne's lying, right? Or Officer Payne's not lying. And that is what he's saying is correct. Like, what portions of this affidavit is relied upon by the FBI giving you the IgG tip, which is investigate Brian Kohlberger, because our work that we did in this case, okay, led us to Brian Kohlberger because of the work off of the family tree. I mean, did Ann Taylor not lay it out? But how else could you take Officer Payne's testimony any other way? I mean, even if Ann didn't lay it out, I think Payne laid it out. Okay. But so I'm trying to compare this to, all right, so we go to Shanna Gardner's case. And let's go right here. Okay, obviously we know that if any of this was to be suppressed, anything that came from it is gone. You're not allowed to use it as evidence in court. So anything that would have come from, so here for Shanna Gardner, her iPhone, whatever came and from that's out. Her iCloud, gone. And her Google account, okay? So here, how the hell did Ann Taylor decide to go about this? In Idaho, the analysis under Franks is a two-step process. The first step considers whether the defendant has made a substantial preliminary showing that the affiant knowingly and intentionally or recklessly falsified or omitted information from his or her affidavit. Okay. And so the answer, how would you argue that? If you're looking at that affidavit, I would say, well, you would go immediately to point to November 29th, when in the probable cause affidavit, okay, and wouldn't you have to ask Payne this question, which is, when you are pointing here to November 29th as saying that officers at WSU found Brian Kohlberger's car, you were alluding to the fact that that's how the progression flowed of this investigation. Right, Officer Payne? Like, that's how you got his name. How was the magistrate in your 19 pages of word salad here, Officer Payne? How are you telling the magistrate how you got to Brian Kohlberger? How he became and is linked to these crimes, these deaths, right? While the Franks court did not define this burden precisely, it is generally held to be something more than conclusory allegations, but less than proof by a preponderance. courts have said that this requires direct evidence of the affiant's state of mind. Okay. You have to get to the affiant state of mind. Because you're going to sit here and tell me that Ann Taylor and her team do not know this standard. In order to get to the affiant state of mind, you have to ask questions that bring that out. What the fuck? Right? When you were writing this affidavit, Officer Payne, you wrote 19 pages, whether it was worked on by 90 of you guys or one of you, right? It doesn't matter. Here's the 19 pages. You read through it all, right? To make sure it made sense? Yeah. And this made sense to you, right? So what were you portraying to the magistrate? That you got to Brian Kohlberger where? IGG is nowhere on here, correct? And that's what led you to even investigate this man in the first place, correct? Because you said your state of mind is that the feds gave you a name, and just like anything, you go and you vet it. You're like, let me go and see if I can get there myself. Like, what are you talking about? Explain to me your vetting process. How are you vetting the FBI giving you the name Brian Kohlberger? First of all, you have to ask where it fucking came from. What part of the investigation did it come from, right? You know, I always say, this is why you have to ask questions. What do you want from me? What do you want me to show you? What do you want? What do you need to see or hear that's going, and that from that something's going to happen, right? So you're going to sit here and tell me that Ann Taylor, who I know is just a plea dealer, as all Idaho public defenders are, the biggest plea dealer is Dana Bose, a complete fool. And but like what? So so he's saying that this affiant, right? We have to get this affiant to describe to us what the hell they were trying to tell the magistrate, right? We don't get to ask the magistrate what she thought of it, right? So we have to get that out of the affiant, right? But how do we get that out of the affiant? Okay. How do I get the state of mind out of the affiant if I don't have an opportunity to depose this person, right? Or if I don't have the opportunity to ask them questions, right? So the courts have said this requires direct evidence of the affiant's state of mind, or else circumstantial evidence of a subjective intent to deceive. Okay. Well, in Florida, now maybe the only record that we're seeing right now, maybe there is some stuff that has not posted on Shanna Gardner's site. Okay. But they say the iPhone warrant is page 1 here. Okay. And the supporting affidavit was submitted by Detective Jason Lamont. So out of these 3 warrants, Detective Johns is involved and Detective Jason Lamont. Okay. The iPhone warrant in the Shanna Gardner case authorizes seizure of 20 categories of information. Okay. And so the way that Shanna Gardner's team is going about it is in each instance described in its broadest possible terms using any and all without restrictions. By way of example, it authorized seizure of any data related to user logins and passwords, and any communication accessed, written, sent, or received, or deleted. Category is boundless in both time and subject matter. The warrant contains no date restriction of any kind and no limitation tethering the categories of data sought to the charged offense. Although the iPhone affidavit sets forth extensive allegations of probable cause against Ms. Gardner's co-defendants, it provides scant allegations against Ms. Gardner herself. So in the Shanna Gardner case, obviously there's co-defendants, right? Now, should there be co-defendants in the Brian Culver case? But it's interesting because basically what they're alluding in the Shanna Gardner case is like, dude, marriage association gives you free reign to do what? Like, what the fuck's going on here? But how did Ann Taylor go about getting stuff truly like, well, first of all, having this Franks to be able to get a Franks, which would be like, okay, if I can't get to the affiant state of mind, then I'm going to have to do it circumstantially, right? Now, whether an omission was intentional or reckless may be inferred in part from the relative importance of the information and its exculpatory power. Okay. However, a court need not draw inferences from the evidence in a defendant's favor. So he's like saying all this shit. Okay. Hippler is. The challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. There must be allegations of deliberate falsehood or reckless disregard for the truth. Ann Taylor has to suck a whole bag of dicks because that affidavit sucks so bad. But Ann Taylor didn't know how to attack it because it's false. It's false where it starts. And so if Ann Taylor is going to be doing talking points on the Idaho4 case, well, Ann Taylor, I ain't paying a damn dollar unless you're going to start with the affidavit and what y'all did with that Franks, because we got to talk, girl. I have lots of questions. How the fuck you guys bobbled the fuck out of this, that you did not get a Franks. And then once you didn't, why didn't you appeal? Why didn't you appeal that ruling? There must be allegations of deliberate falsehood or reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. Well, there was so much. They should point out specifically the portion of the warrant affidavit that is claimed to be false. And they should point accompanied by a statement of supporting reasons. Affidavits or sworn or otherwise reliable statements of witnesses should be furnished or their absence satisfactorily explained. Okay. If the defendant successfully shows an intentional and knowing or reckless inclusion of a false statement or omission of exculpatory information, ready for this? WSU saw Brian Culber's car, right? Those guys that one of them that queried it and drove past it and found it and whatever on November 29th. Okay. You reported the VIN number, right? Mm-hmm. And now let me tell you why they had to act like they never got that. And they didn't know about the 25th one either when it was the 8th one that Pullman police found. You want to know why? Remember everyone's going to talk about this fog light? The VIN number, people. The VIN number immediately would have told you that what? That make and model doesn't have fog lights. That's why they had to act like they didn't have it. Our wires just got crossed. We never got that. But we put it in the probable cause, making it seem like for America that that's how we got to Brian Culver, but we didn't. That was his answer, though. That's why he answered the question the way that he did. We never had that information. We didn't know. We didn't get that until after. What? What do you mean after? What the fuck are you talking about? The November 29th? Yeah, we didn't get that until after we had his name or something like that. But it wasn't before the probable cause was written. That's what Ann Taylor didn't hone in on. And the answer would be yes, right? Because it clearly made its way into the probable cause, right? And you had the VIN numbers, okay? And so when you had his VIN number, you would have saw that he doesn't have fog lights. And if that's not, like, this is proof. This is your proof, which then you know that he couldn't have been the Floyd's car. Not among so many other things, but that is just like, the reason I'm breaking it down this way is because if I have a job to do, I have to know what my job is so that I can do it. If I want to earn a Franks hearing for my clients, how do I do it? How am I going to succeed versus just going through the motions and say, I'm going to file fucking 2,000 pages? Why do you need 2,000 pages to explain these points? What are you doing? I need to understand that. You couldn't explain these points without using 2,000 pages. Like, something's wrong there. You know, being so thorough, save it for the arguments. I mean, I don't fucking know. Like, when you want to say that if you're playing the long game, they hid that Floyd's footage forever. I don't know about that. You want to know how nobody can make a comment to that? Not a single person can comment on that. On when the Floyd's footage was given. You want to know why? Because Hitler hasn't released those documents. The documents being of the discovery certificate. It's a list of everything that Ann Taylor was given and when it was given to her. Until we get that, that comment can never, ever be said. Okay? Okay. If the defendant successfully shows an intentional and knowingly reckless conclusion of the false statement or omission of something, the trial court must then examine whether the remaining information in the affidavit is sufficient to establish probable cause absent the false statement or with the addition of the exculpatory information. Okay. So what would be exculpatory to Brian Koberger? Well, the car having the fog lights would be exculpatory to Brian Koberger because his car doesn't have them if this is the way they want to fucking go about it. Okay. So you would say, hey, you're going to put that vehicle in there, right? Well, yeah, leave it in there. But then what's exculpatory to that, right, is that your next sentence would be, but this car that's traveling, okay, was seen on Floyd's camera and it has fog lights. If a defendant makes a substantial preliminary showing under Franks, the matter moves to an evidentiary hearing where the defendant must establish by a preponderance of the evidence that intentional or reckless falsehoods were included in the warrant affidavit and were material to the magistrate's finding of probable cause. And let me tell you, you need to hone in on motherfucking Bethany, bitches. Bethany, not hone in on how they wanted to interpret Dylan Mortensen's fucking shit. Are you kidding me? No. You go to the phone records and you show that Bethany made the call first to fucking Dylan, you sons of bitches. And if you didn't do it that way, you're dumb. You're absolutely dumb. Bethany calls Dylan. Also, there is no evidence that shows that the crime happened at that time. So we're going to get all into that, but the Bethany calling Dylan and being the first movements to set off this, chain. Therefore, Dylan, you weren't alerted to anything, and then just because of your timing, right? Which we'll handle first, but Dylan didn't call Bethany. Dylan didn't call her roommates. Bethany never hears Dylan calling out for anybody, right? Bethany hears a firework. And that's why she calls. Bethany claims that she heard a firework and saw sparklers underneath her door. And that's why she called Dylan. Why is that being left out? Everybody wants to say, I want to know what Ann Taylor meant by that Bethany has exculpatory evidence for Brian Kohlberger. Yeah, that's what it is. Is that Bethany, what she heard and saw contradicts what the fuck Dylan is saying, which would be ding, 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 in and of itself exculpatory to whoever, because it's going opposite of what Dylan's saying. But guess what? In one of Dylan, in Bethany's interview, she said that when Bethany called Dylan in Bethany's interview, she said, I told her, hey, I asked her, did you hear that firework bang? But in Bethany's interview, Bethany says she said yes. You understand that? It's Dylan outside with Noonan's who's wondering, hey, and then remember she tries to ask Bethany while she's being interviewed by Noonan's about the whole, oh wait, did I hear that? Wait, what did I hear what? Wait, excuse me? Unbelievable. Okay. Dylan's trying to bring in Dylan at that point, or bring in Bethany at that point to be interviewed almost simultaneously. Again, I will say this till I'm blue in the face. Just like Jill Bolton had horrible researchers for the Dan Moore case, Jill Bolton is one fuck of an attorney. Okay, but you're only going to be as good as your motherfucking researchers are. Okay, and who can connect the dots and who can play the loop all the way through and not get stuck in shit. And when something doesn't fucking make sense, you can't just move on. You got to understand why it doesn't make sense. And Ann Taylor, maybe we'll never know one day, maybe we will. Who the hell was going through all of the material and playing your loop all the way through? Who was it? You know how many hours you spend in a day on a case when you're going and digging through the discovery to put something together for somebody that's saying that they're innocent and that they didn't do this? Where do you start? Well, I could tell you what you don't do. You don't go and fucking sit down with your fucking client and ask them anything. Okay. You go and you get all the shit and you lay it all out. You start putting it together in a timeline, and you're seeing what the case is. What's the state's case? What's the state's case, and how are they going about showing this? Okay. Then obviously the person, now think about this. If your client doesn't know any of these people, doesn't know who these people are, blah, blah, blah. So like Dan Moore, for example. Do you know Brian Drake? No, never met him, never talked to him. Okay. Who do you have beef with in the community? Who doesn't like you? Who knows your routines? So here's Ann Taylor. She wants to go and get this Franks because this is just, they lied in a probable cause affidavit, and we know that they lied. We all know that they lied, right? It's a fact. If you had to put a gun to those prosecutors' heads and say, hey, if you lie here, you're goner. Did you lie in the probable cause affidavit? Is all this bullshit? Yeah, that's not how we got to Brian Culver. Yeah. Because without IGG, you don't get the name to even start investigating. Okay. You don't get to start doing this vetting. So why wouldn't you just start? Why wouldn't you just be saying that? Especially how good IGG is going to be and how it's going to, save all these, I should say save all these lives, but give a name of the person that committed murder, right? So okay, going back over here. Here, the defendant claims that 17 search warrants. The reason that they're saying 17, okay, is because it was basically you used, right? You can get this from Cyray's little clips that you went ahead and took an affidavit, right? And kept it all the same and kept just recycling it and using it as you continue to go. And so therefore you continue to use this false fucking shit to do all, So in the Brian Culver case, right? 17. Now here in Shanna Gardner's case, which is so complex. It's so complex. So complex, right? Shanna Gardner's case is a murder for hire case. You got the ATF. It is so complex. You got people that weren't even being charged that were involved in this murder. This case is going to be amazing to watch in terms of a learning and just like, let's see how real lawyers litigate complex cases for their client. So Shanna Gardner's only trying to toss 3. Okay. In the same thing, in a huge complex case. And here, Ann Taylor and them, 17. Now, first of all, would you even waste your time tossing anything that didn't matter? Just because you really want to hone in on the stuff that matters. So 17 search warrants out of the 25 need to be tossed. Here, the defendant claims that 17 search warrants issued in the investigation of the crime were based on false, misleading statements and or omitted exculpatory information in the various search warrant affidavits. His proffer is arranged by issue, of which there are 13. There's 13 issues. Because I would think that if there are 17 warrants that you're trying to toss, that there'd be 17 issues. But hey, what do I know? As mentioned, for convenience sake, the court granted an evidentiary hearing on the IGG issue. Well, we should ask ourselves why. It's very interesting that you're just out of convenience. Why would it be out of convenience sake the court granted an evidentiary hearing on the IGG issue? How is that convenient? The other thing is that here's Shanna Gardner shit isn't all into different ones. It's all in one. Here, Ann Taylor took and made all these separate motions. What the fuck are you doing? Why? This evidence would be considered under the preponderance of evidence standard, while the proffer on the remaining issues would be considered under the substantial preliminary showing standard. So Basically, I'm granting you an IGG hearing. Basically, you've already showed. I'm already saying that you showed me. There's proof here. Okay. And I don't know if this confused Ann Taylor. Did it confuse her what the purpose then there was like with this? You understand? So like on that day where we all thought that we were going to see the whole thing. And then they were like, well, no, some of it's going to be closed, but you guys can be in for. And it's just like, if I was Ann Taylor, one of my arguments would have been like, Your Honor, I am not going to worry if I say something if I shouldn't, or hey, is this now public? Or I am zealously going to be arguing orally as well as asking questions to ensure that my client's rights are upheld and that he has a fair, all this shit. Right? I don't need to fucking worry about if I say something. Like, no, it's just open to everybody or close it because I'm not playing these games. Right? That's Ann Taylor's position should have been that and that alone. But she was basically granted. There was a Franks, and the Franks was on the IGG. Like, and I think I would have needed to have some clarification here. Because the issue with this IGG granting of I'm going to tell you how this doesn't make any sense. I'm telling you that this affidavit is bullshit on how it got to my client because they're not saying that they used IGG. So if you're granting me that, right, I just have to show you and have somebody come to the stand and say, yeah, Your Honor, like Payne did, and saying that everything flows from IGG. Without IGG, you don't get to anything else. So everything goes. Because that's what Payne said. So why aren't you saying that, Ann? I would just be calling Your Honor out and saying, Your Honor, this doesn't make any sense. Okay, you're granting me a Franks hearing for IGG. What do you mean by that? Because the only argument that there should be is that in order for probable cause to exist, okay, you have to talk about the IGG because that's how you truly got to him. That's where that name ever came from. Because you also didn't write in your probable cause affidavit that you got a random tip from an unknown source. You understand? Let's say that you don't want to say IGG, but they didn't even go as far as to say that there was a tip, that the FBI tipped them off to investigate Brian Kohlberger. Where's that? Where was that part in the 18-page affidavit? But I mean, I think this was very confusing because I look at Shanna Gardner's situation. It's like, okay, how are they going to, what's their arguments here? And well, their first argument is that although the iPhone affidavit sets forth extensive allegations against a probable cause against Miss Gardner's co-defendants, it provides scant allegations against Miss Gardner herself. Of the allegations that do concern her, nearly all describe conduct occurring after the murder. But that's not what she's being charged for, like an accessory after the fact. You know, you're charging her with first degree murder, premeditated murder. And that's one of their arguments, is that what she was charged with isn't what probable cause was awarded for. So The only pre-murder allegations are that Miss Gardner was previously married to the victim. What? And is presently married to and separated from the co-defendant Mario Saldana. Take a look at this shit. Like, this is wild as fuck. But this is the same type of argument that I think Ann Taylor needed to make black and white. In her case, look at this. So this is the factual background, and this is, again, we're going to be kicking out this. They want this warrant to go, and although the iPhone affidavit sets forth extensive allegations of probable cause against Ms. Gardner's co-defendants, it provides scant allegations about Ms. Gardner herself. Of the allegations that do concern her, nearly all describe conduct occurring after the murder. The only pre-murder allegation, are that Miss Gardner was previously married to the victim, Jared Bradigan, and is presently married to and separated from the co-defendant, Mario Fernandez Saldana. The remaining warrants repeat substantially the same factual allegations. And this was kind of how Ann Taylor was going for it, right? She was going with it by saying, like, you're this boilerplate bullshit, but she doesn't ever say the words boilerplate. She doesn't do this. But here in the Shanna Gardner case, it's like being married to somebody gets you, that's probable cause. Being divorced from somebody, that's probable cause. The iPhone affidavit contains a section titled Information Regarding the Function of Cellular Devices Supporting the Obtaining of Data in its entirety. Its entirety. Okay, hold on. In which Detective Lamont describes the vast quantities of personal information stored on modern cell phones and asserts that the entirety of the device is necessary because it, quote unquote, may convey communications between parties and identify suspects, co-conspirators, associates, witnesses, and other individuals who may have involvement or knowledge of crimes. What the fuck are you talking about? What? Then there would be probable cause for everybody all the time. Just throw probable cause out the window, because let me just get your phone and then I'll tell you if you're innocent or not. If we can't find anything off your phone, you're free to go. But you don't need a reason, though, to get into my phone. You understand that? So how hard is it to make an argument about this? And this is the difference between a lawyer and a litigator. Ann Taylor went to law school. Great, you're a lawyer. You passed the bar. But can you litigate? Can you oral argue? Do you know the case? When they throw something at you, are you able to know what the comeback is? When something just doesn't make sense, but you know how to explain it, can you do that? So are you a litigator or are you a lawyer? Very rarely do you find that you have both. And when you do, those are the ones that are worth the money. This generic rationale, untethered to any specific crime, like, is like, you cannot write up. And that's why I want to see how Cyree wants to handle something like this. Like, when he's like, here's the sample of how you would write up this stuff. Yeah, but it's for preservation. Okay. Cyree's big thing is to preserve the material, which I'm all for. Absolutely. Amen. Preserve it so that if you should ever need it, okay, because as the digital age works, is that stuff can get wrote over, blah, blah. Okay. So here, any specific allegation against Ms. Gardner or any specific category of evidence was the sole justification offered for seizing Ms. Gardner's entire phone. It was accepted by the courts. The warrant was signed February 22nd, 2023. That is a whole year after Jared Bridegan was murdered. Jared Bridegan was murdered February 16th, 2022. Okay. Now, usually the returns on these search warrants, this amount of time, oh, what the fuck are you doing? What's going on here? You don't return search warrants 3 months later. But do you see how it's just like period? Like you're making your point like this was accepted. How was this accepted? Next. So that's all they say though. Look at this. In Shanna Gardner's, this is her filing. Okay. A iPhone warrant. 1 page explaining this. B, now it's the iCloud warrant. Okay. On April 3rd, 2023, again, a year and a couple months after the murder of Jared Bridegan, the court issued a warrant authorizing law enforcement to seize the entire contents of Miss Gardner's iCloud account for the period November 1st, 2021 through March 27th, 2023. Now, what happened right before this? Well, in March of 2023, they arrested Mario Saldana as being a co-conspirator because they got Henry Tenon to say that he was the shooter, okay, and to take a deal in March of 20, or they already talked to him in January of 2023. So they got Henry Tenon to say, okay, yeah, I was the shooter and that I was murder for hire and that Mario paid me, but didn't pay me, but maybe paid me. Okay. So the words, they went and arrested Henry Tenon in August of 2022 on an unrelated case that was for a traffic violation. Okay. It was all bullshit. Anyways, and they kept him in jail in the county and they were monitoring everything. Okay, let's see if everyone starts to squirm. Then all of a sudden, Henry Tenon's over here like, yeah, I shot him. Henry Tenon didn't shoot him. Henry Tenon, they were threatening him with frying his ass, with fucking first degree, this is a capital case and we're going to kill you. But if you do X, Y, and Z, you're probably only going to do 15. So save yourself. So it was after all this craziness, because that background matters. Why the murders in 2022 in February, okay? And then so then they arrest Henry Tenon off of unrelated stuff, and then they're spying and watching on what people are doing, okay? So that's why this date matters. April 3rd, that's after the arrest of Mario Saldana, who's soon to be her ex-husband because, but anyways, the court issued a warrant authorizing law enforcement to seize the entire contents of Miss Gardner's iCloud account for the period of November 1st, 2021. And it's really important to understand that Henry Tenon told the authorities that he had never spoken to Shanna Gardner ever in his life. Okay. And so they go to this period. Now, the supporting affidavit was submitted by Detective Christopher L. Johns. And this is who Diana Nash is just going to tear this motherfucker up. Like, phew, I'm there for it every day with popcorn. We're going to be gavel to gavel. The iCloud warrants disclosure provisions, paragraphs 1 through 9, demand without subject matter or limitation The entirety of all emails, all iMessages, all iCloud backups, all Apple third-party app data, all photos, all videos, all location data, all FaceTime logs, all transaction records, all device identifiers, and all files and other records stored on iCloud. Are you kidding me? Think about this. That's like somebody coming in your home and just saying, I have free reign to everything in here, whatever I want, just because what? Because of what? What? Well, yeah, because you were married to so-and-so. We just arrested him. And yeah, like he totally killed your ex-husband. And what does that have to do with me? Wait till we find all of this shit. Because there's probable cause. If you let us search in there, we're gonna find what? What are you gonna find? What is in an Apple or an iCloud that you can find that's gonna show you that I committed murder? Well, a separate provision after this all happened limits the information to be seized by law enforcement to evidence of violations of Florida statute section this, premeditated murder, and child abuse. But this is only after Apple has delivered the entirety of the account to the police. When they went ahead and tried to put this provision in, guess what? It was after. You guys already got everything. Are you people fucking high? The iCloud warrant acknowledges that the requested time frame of 16 months is longer than would be typically requested. And they justify it by saying that the expansion on the ground that this is a contract murder for hire, and that that there was detailed planning, execution, and cover up. But there's a problem here. That's not what you're charging her with. Premeditated murder and child abuse. Detective Johns did not, however, seek a warrant for murder for hire, nor did the issuing court find probable cause for that offense. The warrant was signed April 3rd, 2023. The return was filed May 1st of 2023. Now, the Google warrant and affidavit. So also on April 3rd, 2023, the court issued a warrant authorizing law enforcement to seize any and all files and or content associated with Ms. Gardner's Google accounts from November 1st, 2021 through March 27, 2023. That's the Google warrant. The supporting affidavit was also submitted by Detective Johns. The Google warrant's disclosure provisions, paragraphs 1 through 24. Without subject matter limitations to the entirety of all Gmail messages, all Google Drive contents, all Google Docs and Sheets file, all this shit, all click history. You know that, so I underline that because of the whole Brian Culver case. All this shit. Okay. Again, geolocation. Again, this is only after Google has delivered everything to law enforcement that they did this whole provision thing. Like the iCloud, a separate provision limits what may be seized to evidence of the charged offenses. But that came after they already had everything. The Google warrant further authorizes seizures of all evidence which tends to show a crime has been committed. What the fuck could show you that a crime has been committed in any of that shit? Any crime, not merely the offenses for which probable cause was found. Like, are you kidding me? Like, judges are just letting people feel they're signing whatever. The return was filed July 14th. July 14th. Are you kidding me? You got it on April 3rd. That's not how that shit goes. The hell's going on around here? Now, on August 17, 2023, the grand jury returned an indictment charging Ms. Gardner with the first-degree murder of conspiracy to commit murder, solicitation to commit murder, capital felony, and child abuse. Now, here's the arguments. And again, it's like, how did Ann Taylor go about arguing? Like, how is this going to be a different outcome? How can you expect a different outcome? So first of all, their first argument is that you must be particular describing the place to be searched and the things to be seized. You can't just say everything, okay? And until somebody steps up, and I think our best option here is that Judge Kite can do that. I truly think that she can make this happen. But this is wild. Okay, this is wild. The warrants challenged here are constitutionally defective on two independent and reinforcing grounds. So this is all I cared about was, first, the supporting affidavits failed to establish probable cause as to Miss Gardner personally and as to the specific places to be searched. Second, even assuming probable cause, the warrants themselves are not particularized as the Fourth Amendment in Article 1, Section 12 of the Florida Constitution requires. Same thing that I believe Ann Taylor was talking about. You cannot just fire off these general warrants, right? So the affidavits fail to establish probable cause. Probable cause is not a bureaucratic formality to be satisfied by reciting generic investigative boilerplate. There it is, Ann Taylor. There it is. When's the last time you've actually seen those words written? I was like, thank God. Like, when is this boilerplate template fucking shit gonna go away? Funeral potatoes, yeah. So we go back to then. Let's go back over here to the Franks that Hitler was doing, right? Let's go over here. And again, the defendant proffers arranged by issue, of which there are 13. As mentioned, for convenience sake, the court granted evidentiary hearing on the IGG issue. This evidence will be considered, okay, blah, blah. Right over here. In issue 1 and 2, defendant challenges Exhibit A, which is the affidavit, okay? Defendant has not met his Fangs burden on issues 1 and 2 challenges to Exhibit A, which is a probable cause statement that individual investigative officers appended to their affidavits in seeking search warrants. So this was the Exhibit A. As defendant notes, Exhibit A was a working document drafted as a group effort among the multiple investigative officers working on the homicide investigation. In their respective search warrant applications, the officers submitted and swore to Exhibit A as their own. This is how Ann Taylor went about it. Like, even though it was the product of a collective effort and not necessarily limited to the swearing officer's own investigation. In issue 1, defendant challenges this approach, arguing that Exhibit A was, quote unquote, treated as a wild card to easily get a warrant. Okay. Right? Well, can you explain how this is a wild card to easily get a warrant? That would not be where I'm focused, man. I'm focused on this is a goddamn farce. Okay? In issue 2, he challenges alleged misrepresentations in Blaker Exhibit A, Mowry Exhibit A, and Payne Exhibit A. Defendant has not met his burden under Franks on issue 1 or 2. First, it is not improper for law enforcement seeking a warrant to swear to matters within the collective knowledge of other officers involved in the same. Okay. Second, defendant does not demonstrate in his proffer any misrepresentations or omissions, much less that they were made intentionally or recklessly or had any effect on probable cause. Defendant submits those. These exhibits are emails between Special Agent Nick Balance of the FBI and Detective Brett Payne of Moscow Police Department, in which they are exchanging drafts of a probable cause statement. In addition to the draft Exhibit A, defendant has provided with his proffer the following 3 actual Exhibit A's, which were submitted by officers with their search warrant applications. The statement of Dustin Blaker, the statement of Lawrence Mowry, right there. See where it says Google. So we're going to go to that. And then the statement of Brett Payne supporting the warrant application for defendant's arrest. These actual Exhibit A's are not identical to the draft Exhibit A or to each other. Nevertheless, defendant challenges them collectively in issue 1 on grounds that they are largely the same statement and contain the same core set of elements. Why you can't have it both ways. If y'all worked on something jointly, then there should just be one probable cause statement, right? How are they different? You'd want to point out that Detective Blakers is saying that Brian Colbert never made the loop-de-loop, that he just went straight home. You guys understand that, right? But I don't understand why the fuck, like, what do you, like, I would just be, it's just very simple to say, if you're going to see all of this together, like that everybody worked on this, here's the probable cause statement, here's the 18 pages. Everybody worked on it. It was a working live document. And everybody's swearing under oath then. But wouldn't you need to, like, I don't know. When did you find that out? Right? Think about this. Well, exchanging in the docket when here's your motion for this, then the state's coming back and saying whatever. Okay. But think about this. Why wouldn't you just make a period to say, hey, the state said that everybody worked together and this was a live, living, working document? Then why are there 3 different versions? And the 3 different versions are significant because of what? If it would be, like I just said, first of all, you're claiming that Brian Colbert took the loopy-loop. But then in Dustin Blaker's one, it doesn't. And it says that he got straight home, and that's where you're going to find, that's what's giving you probable cause to get into his apartment, because there's going to be blood and shit and all that crap in there, right? It's the evidence of a crime, right? Because he's going to trail in there. But what does that have to do about his computer? Shouldn't you have to, go in there and see if you find any, you can search the apartment, but you're not going into any of the devices or anything like that, right? Because you're just supposed to be looking for, like, blood or fiber. You get what I'm saying? That's what that would allow you. But how are you getting into the fact that you can go through his devices that would be there? His refrigerator, his microwave, his stove. What the fuck's in there? Woohoo! 5 gifted memberships. Thank you so much there, because is it, what is it, 8646? But what is that end of that? Okay, so she wants to fucking twiddle fuck around with this shit. Defendant has not demonstrated any impropriety in law enforcement's execution of Exhibit A based on collective knowledge. Well, is that truly her argument, or is this just Hitler fucking spinning? The presumption extends to hearsay information from government officials who, while engaged in investigatory responsibilities, discover evidence of possible criminal activity. And so you're sharing it, okay? The presumption arises from the belief that facts gathered in the course of an investigation are unlikely to be based upon mere speculation or tainted by personal involvement with the suspect. So was Ann Taylor arguing that this was all purely speculative, right? You're speculating that he did this and that because there was no more cameras, the car had to have done this versus, I don't know, maybe the car went where Eric Gower's car was, chilling. Why wouldn't Ann Taylor argue that you're leaving out exculpatory evidence such as that there was a vehicle circling prior to 3:30 in the morning? Right? Wouldn't that be exculpatory? That a car started circling and going around that area before that time? It's just Lana, you're amazing going back and forth between these two to showcase. We appreciate you so much for not moving forward until it's understand. Yeah, because it's entropy. Thank you. I was having a hard time putting the E's together there. Thank you. Appreciate that. So defendant acknowledges that a warrant can be based on law enforcement's common knowledge, but argues that officers cannot sign a collectively drafted affidavit. Why would this be your fucking argument? Do you have case law on this? Why would you ever think that this could be your argument unless you had what are you using to back it up? Otherwise, it misleads the magistrate into believing that the swearing officers drafted the affidavit and performed the work therein when it was a collective effort. No, what would mislead the magistrate, in my opinion, is if the work of certain people was never used and you're trying to bolster your claims by making it seem like the FBI gave you the material. Just because you write the words that you consulted with an FBI agent, that doesn't mean that the FBI agent gave you the material, okay, and stamped it for its approval to go into an affidavit. I could call somebody up right now and talk to them about something, and I consulted with them. Woohoo! Fuck is calling me. Oh, sweet. Hey guys, this is great news, but ready for this? It's cool. It's cool news. Broken Plea debuted at number 8 on the New York Times bestseller list this week. Thanks again for having Chris on. He really enjoyed it. That's from Russ, letting us know here at 12:32. Let's fucking celebrate. I'm gonna do a shot. I'm gonna text Chris and say, "You son of a bitch, look at you roaring." I love shit like that. God, people got to be so fucking pissed. Number 8 on the New York Times bestseller debut. Boom, bitch. Nice job, Chris. Nice job, all of you guys. So shout out, we're all being congratulated that had Chris on. He said, no small part to you. Broken Plea debuted at number 8 on the New York Times bestseller list this week. Thanks again for having Chris on. He really enjoyed it. Senior executive from Thanks in no small part to you. Oh, Russ, thank you so much, Russ. Appreciate that. Oh, that's awesome news. Woohoo! His book. Congratulations. Okay. Now, like, look at what they're focused on. Unless you have something like why they did it to show like it was being like, you're doing this to deceive. Like, that's what you're supposed to show. This hyper-technical argument has no traction under Franks. Exactly. As far as I'm concerned, fuck that. Because you know how much more shit there is that they want to fucking pony up a fucking piece of paper together and jack off in a circle? I don't give a fuck. It's all shit. Why the fuck would you waste your time with that shit? Only to piss off a judge. Well, people that don't litigate don't know that, right? Even if a search warrant affidavit does not have specifically identified the precise source of the information from within law enforcement, it is still sufficient to support probable cause. If a reader would reasonably infer that the information came from other law enforcement personnel, that's how he's taking that, okay? All right. So then I want to look over here and I want to see how good I think Shanna Gardner's defense team did with their Franks. Well, probable cause is not a bureaucratic formality to be satisfied by reciting generic investigative boilerplate. It is a substantive constitutional requirement. This isn't some bullshit. Probable cause is real. Okay. So it's a substantive requirement that protects the innocent and the guilty alike from the unchecked exercise of state power. A search warrant affidavit must establish 2 distinct elements. First, that a particular person has committed a crime, and that's the commission element. And second, that evidence of that crime is likely to be found at a specific place to be searched. That's the nexus element. They are citing Burnett versus State and Illinois versus Gates, and they're also saying that both elements must be established by specific articulable facts, not inferences, not speculation, or an officer's generic training and experience. The 3 affidavits here fail on both counts. That's how Shanna Gardner's team, Jose Baez, this is how they're going about it. Okay. And meanwhile, Ann Taylor's over here wanting to talk about. So, all right, so we can move on to where she gets to here. The defendant's evidence demonstrates there were several law enforcement agencies working together in this case, including the Idaho State Police, the Moscow Police Department, and the Federal Bureau of Investigation. During his testimony from a prior hearing in this matter, Detective Brett Payne from the Moscow Police Department explained that agents from these 3 agencies were co-located at a command center up at the Moscow Police Department for purposes of the investigation. Well, guess what I was told? That is not true. And that everybody left except for 2 people. And so, Ann Taylor, tell me that you have the same information. Okay, because if these people were not co-located and stuff was not shared, these agents were assigned different investigative tasks. Okay, where is that, Ann Taylor? You should, pertinent information they learned in performing those tasks was then exchanged and transmitted into a working probable cause affidavit. Oh, was it? The information from the draft Exhibit A was then incorporated by law enforcement in varying degrees into the Exhibit A's supporting the search warrant. Okay. Importantly, the Exhibit A's challenged by the defendant included statements alerting the magistrate that the affidavit, or the affiant rather, was assisted by other law enforcement agents, and that the information contained within the Exhibit A was based on information provided by these other agents. And so supposedly she had a long game going here. And so she was going to blow this up at trial. But now, what did I tell you guys? There'd be no fucking case law on this shit, and there wasn't. Further, the defendant has not cited to a single case supporting the proposition that law enforcement's use of a working probable cause affidavit is improper. What'd I say? God damn it. How do you have an argument as a lawyer and you can't find case law to back it up? It means it's probably not a good argument. Okay, now, this is where they fucked up. Further, under no circumstances could it be reasonably concluded that had the swearing officer disclosed which members of law enforcement provided which piece of evidence, the magistrate would not have found probable cause. You have to put it in the order. Okay, then it would. Because you can't get, because if whatever portion that they would have done is not able to be done because this portion doesn't exist, that's where you suck the dick, Anne. Or come out here to the public and tell us that we're wrong. The defendant has not established that alleged misrepresentations in any of the 3 challenged search warrant affidavits compels a Franks hearing. Okay. This is why you don't break it all up, Anne. Okay? Because this is just stuff that you'd want to say just was false. Misrepresentation. She's claiming that the defendant claims that Sergeant Blaker attributes discovering the knife sheath to Idaho State police officers rather than Detective Payne. What? However, as the state correctly notes, defendant's challenge is nothing more than a quibble over semantics. And now think about what Brent Turvey is saying. Think about what Brent Turvey is saying, God damn it. This is not if the fucking sheath was on the flow. Brent Turvey has a lot to say, and this is probably why. Like, dude, what are you doing, Anne? Why did you break all this up? Girl, I need a shot. Let me see if I can get a shot delivered up to my office. Hey, Sue, are you busy down there filing, girl? Okay. Why don't you pour me a nice glass of shut the hell up, Ann Taylor? Make it hot. I like it spicy. Turvey isn't the leak, by the way, guys. Promise. Promise. I hired somebody and I asked if I could just call her Sue instead of her real name. And she's like, excuse me. I said, is it okay if I just call you Sue? I would not like to dox you on my show. I'm totally kidding. There's nobody here working. It's just me. It's funny. Hey, Sue, can you bring me up a little something, something? Thanks, girl. I should hire somebody to deal with my ass. I love when Lana gets crunk. I wish it happened more often. Dealing with this fucking bullshit. My live tonight's gonna be lit as fuck on Turbo Boy, Alan Jackson, and David Nannity. It's gonna be mind blowing, to be honest. I'm not happy that I have to do the live and show it, but it's who I am. And if I find something, I mean, I just can't. It sucks, but anyways. Grand jury transcripts. Once discovered, Detective Payne notified ISP investigators, who then collected and booked the sheath into evidence. Like, Anne, like, look at this. In fact, it was Detective Payne who was the first investigator to discover the knife sheath. What? What Sergeant Blaker stated was, I was later advised by ISP investigators they located a tan leather knife sheath lying on the bed next to Mogan's right side when viewed from the door. In fact, it was Detective Payne who was the first investigator to discover the knife sheath. Grand jury transcript. Once discovered, Detective Payne notified ISP investigators who then collected and booked the sheath in evidence. Excuse me? But can we get some really good clarification on this? Because I don't even think Hitler understands it. At best, I said, Sergeant Blaker's use of the word locate is ambiguous as to whether it means discovering or collecting. What? Under no reasonable reading could it be characterized as a misrepresentation, let alone an intentionally or recklessly false one. And you totally fucked to let Hitler be able to wiggle out of this is insane. Because she's not hitting the arguments. The argument here is that it's entirely different. It's entirely different than what the fucking what. This proves to me, you're going to sit here and tell me that you didn't use any of the documents from the lab reports and the notes and then the pictures. The second allegation, misrepresentations are made above. Oh, Jesus. Supporting the Google warrant application. Respectively, defendant claims that both detectives simultaneously claim to have done cell site location information work, as well as work to determine whether the defendant's cell phone was in the area of the King Road residence. This is how they went about it. Now, let me. Defendant notes, however, that both detectives admitted at a subsequent hearing in this matter that it was actually the FBI, CAS agent Nicholas Balance, who performed the location work that the detectives then used to complete their respective affidavits. And do you understand here is that's where Nick Balance is going to say, no, the fuck I didn't. That agent Balance was the individual who actually did the location work, does not render the detective statements intentionally or recklessly false or even misleading. What? It was never done, period. It was never done at that point. Okay, let me see. So basically, Ann Taylor does not know how to explain to a judge how people lied. Take a look. Okay. So this is how. Okay. I just read this to you guys about the next. These are the two elements, okay? The affidavit fails to establish a nexus between Miss Gardner and the crime. Okay. So this is how you would have done it. The affidavits failed to establish a nexus between Mr. Kohlberger and the crime. Okay. So let's see how this would be if you go this route. To establish the commission element for premeditated murder, an affidavit must provide facts sufficient to support a reasonable belief that the named defendant premeditated and caused the death of the victims. or victim. The affidavits here do not come close. Okay. The affidavits here do not come close. Well, why? Ready? They allege no facts placing Miss Gardner at the scene of the murder. Where does it say that in Ann Taylor's argument? What the fuck? They allege no facts placing Miss Gardner at the scene of the murder. In contact with the alleged shooter or shooter on or around the night of the murder, involved in planning the route or connected to the weapon used. Okay. The affidavits are replete with allegations concerning other suspects. Mr. Fernandez Saldana, Mr. Tennant, and Mr. Biggerstaff. But those allegations cannot be imputed to Miss Gardner by association alone. Nuts. Look at this. Just because you're married to the man, or you were, or then like, so think about how Shanna Gardner's team is going about this, and what the fuck did Ann Taylor do? Because they're trying to get the same shit tossed. The law is unambiguous on this point. Proximity to a suspect, even intimate proximity, does not supply probable cause to search that person. There you use right there, Ann Taylor. Look at case law. Where the standard is probable cause, a search or seizure of a person must be supported by probable cause, particularized with respects to that person. The fact that the probable cause exists to search or arrest another person in the same household cannot be bootstrapped into probable cause to search the spouse. Fucking A. Look at that. United States versus... Look at this. Ann Taylor got paid how much money? Sorry, Lana. Maid Sue took the boat out and is a little tipsy. She fell over, but thank goodness for those DDs. She's floating. Oh my God, I know, right? The double Ds always keep you afloat and they always save your drink. That shot is going to be a minute. She's out in the pool right now. Sue is my pool girl, maid, and sexitarian. Lana appreciates every single one of you incredible humans. Thank you all. Thank you. Thank you. Be safe. Back to work I go. Back to work. So presumption of guilt are not lightly to be indulged from mere meetings. So a hunch dressed in a marriage certificate is still a hunch. Who wrote this? I just want to call Diane Menashe on the phone and just say, girl, I'm reading your filing. Pure fucking amazingness. Like, whoever actually wrote this shit, hands down. You know, a hunch dressed in a marriage certificate is still a hunch. The affidavit's reliance on Miss Gardner's marital relationships to the victim and to a co-defendant as the primary basis for suspicion is constitutionally insufficient. Now, the affidavits fail to establish a nexus between Miss Gardner's accounts and the evidence sought. Even where probable cause to suspect a person of a crime exists, a separate and independent showing is required that evidence of the crime will be found at that specific place to be searched. There's your case. There must be, in other words, be a nexus between the place to be searched and the evidence sought. Again, the best analogy I can give you is I'm having a pool party and I want people want to fucking have rafts and floats. Why are you in my office looking for rafts and floats? There's no rafts and floats in here. You would never do that. There's no nexus between my office and the pool. Get your ass to the fucking shed and pull that shit out, okay? But it's no difference. That analogy, in my opinion, is the best way to explain. Like if I'm hungry, I go to the refrigerator to get food. I do not go to my neighbor's fucking dick, okay? There's no reason for me to be over at my neighbor's. If I'm hungry and I'm at my house, I go to my refrigerator and I get my food out and I eat it, okay? Why am I over at my neighbor's in his bed? Why are the cops over here doing this? What are you doing? What are you searching here? Hunches and bunches. Well, that nexus must be grounded in specific articulable facts, not conjecture or inference from general propositions about criminal behavior. Exactly. Okay. And you know what this is from? When a guy's gonna go commit a crime, he turns off his phone. The fuck, you can't say it. And that belonging in an affidavit is laughable. I know about my training experience that when people want to go commit crimes, they turn off their cell phones. So therefore, I need to be able to search that guy's cell phone. What? And the judges are like, yeah, that sounds great. Get the fuck out of here. No, it's not great. And go get probable cause. And if John Biggerstaff said, hey, we were having meetings and Shanna Gardner's right there and we're all planning it out, use his fucking name and say what he said to create probable cause as to, hey, yeah, and I sent her a bunch of fucking emails back and forth because we were planning this murder. Do you know how, I mean, that's how you develop probable cause. Why are we saying this wild, crazy shit that doesn't make any sense? That, oh my God, a guy that normally commits a crime, he's going to turn off his cell phone. And so I need to be able to search your phone because I can't place you at the crime scene. But I know that if I get into your phone, I can circumstantially do a lot of things. They had at their disposal here John Biggerstaff, a co-conspirator. They had Henry Tennant. Why aren't they saying if Shanna Gardner is 1000% involved and she did this plotting and planning, when did y'all do this? Because let's go look at a date that y'all did this, that y'all were together. And hey, we have reason to believe that Shanna Gardner was with John Biggerstaff, Mario Saldana on this date when they were over there at John Biggerstaff's house planning and plotting this murder. And we have reason to believe that what will prove that to be true is Shanna Gardner had her cell phone with her. And so we were asking to see her geolocations on, let's just say, January 20th, 2022. That's probable cause, right? That's specific. That's particular. How we ever got away from this, the only people that we can blame are prosecutors that are writing this shit up for actually the officers. That's what's happening nowadays, is that the people that are actually writing up these search warrants or these subpoenas, they're actually the fucking prosecutors. And the judges, because the defense attorneys they don't have any power. They're not the ones engaging in this shit. Okay. They're just the ones that are left to clean up the messes that their fellow law enforcement friends and their fellow brothers counsel are fucking performing and doing. This is ridiculous. Okay, but these defense attorneys aren't speaking out properly. This is the first time I'm actually seeing, without loads of paper being used in word salad, that we actually can understand like these arguments, which are fucking common sense. The nexus must be grounded, like I said. You cannot, they're not conjecture, which is everything that, and that affidavit against Brian Kohlberger was all conjecture, or inference from general propositions about criminal behavior. And that's what Payne did. And it's the same thing that Johns did, talking about when a person normally goes and commits a crime, they're going to shut off their cell phone. They're going to just and that they'll use it though beforehand to case the place. So therefore, I need to have all of their location data. Yeah. Well. The iCloud affidavit does not allege that Miss Gardner owned an Apple phone. You can't possibly have an iCloud without an Apple phone. So first of all, you have to establish that. And it doesn't. Now, how about this? Ready? Where the fuck, where was Ann Taylor with that one for Brian Kohlberger? Remember, you got to start from like very basic, walk them step by step by step. So here, you have to establish that this broad, or Brian Kohlberger, if you're going after an iCloud, that they even had an iPhone or an iPad or any other Apple device at the time of the murder. And when the affidavit was sworn to. It does not allege that she used any Apple product to communicate about the murder. Can you believe that? How do you write up an affidavit and not or say, and you don't say like that this is a plotting and a planning of a murder for hire, and you're not alleging that she's using her devices to communicate, to plot and plan with John Biggerstaff and Mario and Henry Tenon? What? It does not allege that any specific communication, document, or record relevant to the charged offense was stored on her iCloud account. The logical foundation for the warrant. You guys, you know what this means to my heart to see this word? The logical. How is logic not playing a role in everyday law? Your common sense and your logic just don't take a fucking back seat. You tell the jury that every time when you're trying to, panel a jury, right? Hey guys, we're not asking you to park your common sense, and we're not asking you to park your titties. Okay? We want you to keep jiggling them. Jiggle, jiggle, wiggle, wiggle. Who's hating on Ann Taylor? Ann Taylor has a lot. Who's hating on Ann Taylor? I criticize wherever I want to criticize. And I'm examining, like it says, Idaho4 and Shanna Gardner. Frank's side-by-side comparisons in two complex cases. How does Ann Taylor need 2,000 pages in Jose Baez and Diane Menashe and Patrick Crody? They need 14. What are the arguments? So the logical foundation for the warrant that the iCloud account of a person suspected of murder will contain evidence of that murder is supplied entirely by inference, not fact. God, it's amazing. These are arguments. This is logical in and of itself. What in the world is going to be in an iCloud account if you're not alleging that Shanna Gardner A had an Apple iPhone or an iPad or some other Apple device, because that's how you're going to have an iCloud in and of itself. And that she had that at the time of the murder or at the time that the affidavit was sworn. Okay. It does not allege that she used any Apple product to communicate about the murder. You have access to all of these people. This is after the arrest of Mario Saldana. This is after the arrest of Henry Tennant. This is after John Biggerstaff has been working with you for fucking a year and some change. How are you not able to write up a simple affidavit to establish probable cause to get into somebody's shit if you're talking with the co-conspirators that you're not indicting? And they're supplying you this amazing information because she's guilty with y'all. This isn't going in a fucking affidavit. It needs to, and if it's not there, it's void of what it needs. Bye-bye, kiss my ass, it's gone. Now, the Google affidavit fares no better. So we've talked about the phone. We've talked about now the iCloud. And now here's Google. And now this is what Ann Taylor, she was going after the Google for Brian Kohlberger. And so let's see how Jose Baez, Diana Nashi, and Patrick Crody, how they go about it. Well, the Google affidavit fares no better. It does not allege that Miss Gardner communicated by email, used Google messaging, maintained a Google calendar, or relied on any Google product in connection with the charged offenses. Amazing. And that's so what's amazing about this is when they're writing things like Brian has phone number, blah, 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 blah. Okay. The phone number is, and the phone registered back to, correctly back to Brian Kohlberger, and it's serviced by whoever, AT&T. Does it tell you what type of phone it is? Can you get that information? Now, 2 full paragraphs are devoted to generic boilerplate assertions about how criminals generally use computers. Same thing like Brian Kohlberger. When someone's going to go and commit a crime, they will do this, this, and this, and this, and this. So 2 full paragraphs devoted to boilerplate assertions about how criminals generally use computers. Assertions that would justify a warrant to search the Google account of virtually any criminal suspect in any case. And that's what I've been screaming from the rooftops, is that if this is now going to be the norm, then every single one of us, fuck the word probable cause. They can just get whatever they want, because all you have to do is say this and it's on. Because this is what criminals normally do, and we're suspecting you of a criminal activity. So right there, I've now made probable cause, because this is what criminals normally do, and I'm going to list all this stuff. And so therefore, I'm going to need to get into all of your shit, because this is how criminals generally operate. The fuck? That is precisely what the 4th Amendment prohibits. Wow. To say this in this paragraph right here, it must have taken Ann Taylor 500 pages. The affidavit's reliance on the affiant's, oh my God, training and experience. Remember how Ann Taylor, where she was going with that? She was like, well, Your Honor, remember how she was telling Judge? She was on it with Judge. She had it. I think Ann Taylor was possibly threatened, because Ann Taylor was a totally different person in Latah. And then when she got to Ada, woo, I don't know what happened, but how she was and performed in Latah compared to how she was in Ada, it was just night and day. So, but Ann Taylor says the same thing, like, I'm going to use this whole training and experience, then I'm going to use your training records. Because you just opened yourself up to all of this by saying, so this affiant's training and experience or opinions cannot fill this evidentiary void. How amazing is that? Just that sentence alone. I don't give a fuck about your training and experience. Your opinions cannot fill this evidentiary void, motherfuckers. Here's a dick. Suck it. God, that sentence. Wow. I cannot believe defense attorneys are not covering this case. Because Mario Saldana's lawyers are just as fucking fire. And they're just not as well known. But God, is Jesse Dreiser. He is just raw. I think he should be up for Florida Lawyer of the Year. Jesse has been amazing. Has been doing a phenomenal job. Can't say the same about the prosecution. They've been just cheating their asses off over there. So, now, training and experience may inform the interpretation of specific facts that are otherwise established. They cannot manufacture facts that are absent. Just love, God, this is just, and it's just straight from a case. Gates, yes. Look at this. Hey, Ann Taylor, this is what you needed, Shug Tits. They cannot manufacture facts that are absent. That's what happened in the Brian Kohlberger case, Ann, but you could not possibly develop the sentence unless I can see it for myself, and then we can go ham once again on Hippler. Because, Ann, I have to see your Frank's filing. I have to see your 1,010 pages to include those exhibits so that I could then go ham on Hippler. This principle was applied directly to digital device warrants in United States versus Griffith. Did she use that? Is United States versus Griffith cited anywhere in Ann Taylor's work? Because that's all, I mean, that's the entirety of their case in Moscow is all digital. So again, this principle was applied directly to digital device warrants in where the court held that a warrant to search a suspect's home for cell phones was unsupported by probable cause because although the affidavit established probable cause to believe the defendant committed a crime, it offered no case-specific basis to believe he owned a phone or that any phone would contain incriminating evidence. You have to establish that. How do you, by just saying that just because you own a car does not mean that you went and committed a freaking, I don't know, drive-by shooting. And so I get to search your car. You have established that what I drive my car at night, that's on my route home. I mean, come on. These judges just literally passing out like everything just, that's what I'm saying. This is why you have to not waive your right to a speedy trial, because they're arresting people on nothing and they're making cases after that year or 2 years. If you get arrested, you got no waiving and it's speedy trial because they don't have anything. It's the truth. And there has to start being a, no shit, he had a Samson. Goodbye, Jake from State Farm. I don't have time for you today. You can come back tomorrow. Okay. If you don't think I know what the fuck Brian Kohlberger has as a cell phone, we're play it back from the beginning, Jake. Play the whole tape, though. You can come back tomorrow. Fucking got time for that shit. Hour and 54 minutes in. Tell me what fucking phone Brian Kohlberger's had. Like I haven't covered this case for I don't even know how many fucking years. The court rejected the government's argument that because cell phones are, yeah, you know what? Okay, so I think this is where we're going to start talking about like geofence warrants and that how just unconstitutional they truly are. But even Sai thinks they're unconstitutional, I believe. So this would be basically inviting a general warrant. Okay. These are general warrants like, oh, everybody has a cell phone now, so just whatever. But our cell phones are becoming basically our what is stored in our cell phone is more than anything in your house. Everything is in your phone. What if you committed a crime without and they have a geofence warrant and they know that your cell phone was not there or it was turned off, okay? So it wasn't used in committing the act. It wasn't used for the commission of the crime because it wasn't found in the geofence, right? So then how do you get to get into my phone? I wasn't obviously using it to commit in the commission of a crime. They say, oh, you used it to plot and plan it. So that's pure speculation. You have no evidence of that. How do you have evidence of that? Wouldn't you need to go out and maybe, I don't know, if you thought I was casing the joint, go get a search warrant for the geofence in that area, maybe, I don't know what, for the past, month to see if my phone is showing up in the geofence. But then just because I drove by or I'm in the geofence, I'm casing a place. I cannot wait for these arguments. Again, bottom line is just the type of broad warrant the Fourth Amendment was designed to foreclose. The same principle defeats the nexus showing here. Like, again, you have access to John Biggerstaff. You have access to Henry Tenon. And these are the people that conspire to commit this heinous fucking murder. And why aren't you using them to create the probable cause? It's because they can't give it to you, right? They can't give you the probable cause because they truly can't implicate Shanna Gardner. Because what? Shanna Gardner wasn't involved. She wasn't in those meetings. But this should be the easiest probable cause that you could ever develop because you have the co-conspirators talking to you as the government. And why wouldn't you put them in the probable cause affidavit, right? So that you can get this material so that you can, boom, we got her. This to me is simple. That's what you would do. And if you can't do it that way, then you got nothing. You got nothing and you're dealing with fucking criminals to try to make a case and fuck all of that. Jose Baez said it best. This is not what y'all think it is. What's going to be next is that you're going to have jailhouse snitches coming forward. That's why it's important for us to be able to get her out on bail. And that's what would have happened to Karen Reed if she didn't make bail. That's like your next step. Like we're going to start using these riffraff people to come into a courtroom, which I do not think should be allowed. Okay. And any jurors that give an ounce of credibility to these scumbags that go in and I'm going to testify about another inmate. Get the fuck out of here. That's like you as a parent have two screaming, crying kids that their hair is all a mess. There's crayons written and markers all over them. And you're going to sit there and tell yourself that neither one of them touched the other one because their friend said nobody was fighting. And you're all going to believe that? No, look at, like, get out of here. Get out of here. I don't believe that people from jail and prison should be able to testify. And an incentive is that you're going to get a reduced sentence or you're going to get out early. Are you kidding me? Get the fuck out of here. If you have to do all of that, your case sucks. Okay? Your case sucks. And that whole big beyond a reasonable doubt. If y'all need jail informants to get your shit done. Anyways, the heightened concerns for particularity and Nexus is especially acute when the target of the warrant is a cell phone or cloud-based account. As the Supreme Court recognized in Riley versus California, these devices and accounts contain the entirety of a person's private life, family communications, health records, financial information, location history, political views, and intimate personal correspondence in quantities and detail that dwarf any physical search. If you were to come to my house, you ain't getting nothing. You're not going to get anything. If I came to your house and searched it, I'm not going to find anything unless you're a hoarder and it's all going to be shit anyways. Okay? Think about this. In order for me to ever, like back in the day when warrants would happen, you get to go into someone's house. You're not able to come in my office and go through my filing cabinets and look at all my financial shit. What does that have anything to do with if you think that I shot my neighbor because I'm a horrible, I just had road rage and he was an asshole and he started mowing my lawn and I told him not to. He burned it out and I just couldn't take it anymore. I just fucking shot him. Going through my office you're not going to get into this. There's nothing there. So why should you just have free reins of our phones? It should be no different. It should be no different. And how do you ever expect as a law enforcement officer, how do you think that you have the balls to sit down at a table and to type up the bullshit that you're about to type up and go ahead and ask a prosecutor to help your fucking ass, create this so that you can serve it? Probable cause is a tool, right? I have probable cause to believe what? That I did what? You're not going to go on a fishing expedition, right? Well, that's all these fucking warrants are. You knew I was home with my kids, like Shanna Gardner's home with her kids when Jared Bradigan was shot and killed. She's home. Both of her kids, they all come home. She's there. She's baking and cooking and she's doing whatever. She's preparing an order. You have her cell phone, never left. It's there. Right. So your only stake here is that I participated in planning and plotting this, right? So therefore, nothing. What would you be looking for? There should be a specific window for that. So it shouldn't be anything after the commission of the crime, right? Oh no, because then I get to say in a warrant that due to my training and experience, criminals will often, if they're plotting and planning, then after the crime's committed, then they'll talk again. So then I need all of this time afterwards to see what? All of my communications? No. You think that I plotted and planned with these two people? Then you would get to see just communications that I had between that number and my number. Capiche? That's how it would be. That's all you get. You wouldn't get to see free reign of my phone, who the fuck I talk to whenever I want. Like, no, sorry. Because then you can try to create, well, look at this number that's calling 15 times. And, you know, why would she ever call, you know, her mom 15 times? Well, I don't know, because my ex-husband was just fucking shot and murdered. But how you can possibly use that to create your narrative, which is all speculation and pure conjecture, fuck that. Go get some hard evidence. Just do your damn job for once, god damn it. Fuck, is it that hard? Is it that hard? All right, guys. I mean, so I think we can see a clear difference of how they're attacking the foundation, how Shanna Gardner's attorneys are attacking literally the foundation of the warrant. And if Ann Taylor would have attacked the foundation of the warrant, right? And in her defense, Jake from State Farm, we don't have Ann Taylor's 1,900 pages that she filed to clearly get this point across, which hopefully we get soon, but we can't get our hands on it because there's this investigation, this criminal investigation. It's a fucking misdemeanor. It doesn't matter who leaked what, where, when, how. Brian Kober suffered from it. Brian Kober would be automatically, Brian, do you want a trial? All right, you got a trial. Let's go. Why? Because he, just like all of us, have the right to a fair and competent attorney. We have the right to a fair trial. This is called due process, motherfuckers. Brian Kober has that right. And no Dateline leak, regardless of the side, should take that away. And if Ann Taylor's advice was to take a plea deal because of the Dateline leak, well, now wouldn't that be interesting? Get yourself a good researcher. So if you're ever going to go hire an attorney, you ask them who their researcher is. You ask them who their criminal researcher, who connects all your dots, who finds all your evidence. You don't have time to go through all this. If I'm paying you $300 or $400 or $500 an hour, I don't want you going through my shit for $300 or $400 or $500 an hour. That's litigation prices. I want you to litigate for your hourly shit. Who goes through the material? And then storyboards it up for you. Like, this is what the state's case is. This is where the deficiencies are, though, in it. And here's actually the stuff that's boom, 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 that you need to pop on each person and where the shortcomings are. These are all things I've learned along the way, guys. So don't be, you know, it pays to fail. And sometimes failing, actually, you're going to learn a lot more, you know. But trial and error. Speaking of trial and error podcast, hopefully give a shout out to one of our favorite doctors over there. Where's that ruling? What the hell? What the hell's wrong with Tennessee? Dr. Katie Spirko. Hopefully we're going to have her on soon. She's a gem. She's a firecracker. She's a truth seeker. And yeah. So that's our production today. Putting these side by side. Again, it's just very interesting. Obviously, there's a lot of ways to do a lot of different things. There's so many different ways to do it, you know. It's like a sporting event. So many different defenses and offenses that you can run. You have to go with what works for you, blah, blah. People can get the W many different ways. But clearly, Ann Taylor, I mean, maybe the whole goal here was to just get a plea deal. And so it's a win. But us as humans and us as people that have rights, our civil rights to be specific, the Idaho state is just literally thinking they can just fucking bomb us with our rights. that they're a technicality. And I want everybody in Idaho, especially those FBI agents, to know that our rights are not a technicality, you fucking pieces of shit. Okay? Have a good day. Bye-bye now. We'll see you tonight. Don't be late, 9:30. It's going down. It's going down. It's going down in the DMs.